Thank you, Mr. Chairman. Thanks to both of you for being here. Mr. Garcia, I'd like to start with you. I can vouch for the fact that Judge Griffith speaks very highly of you and has for years. He's a good man, and I'm honored to know him, and I know that you're honored to have worked for him and also to have clerked for Justice Kagan. I've got a few questions. So in the brief that you submitted in the Our Lady of Guadalupe case, Our Lady of Guadalupe versus Morrissey-Burrieu, you represented the respondents, and in that case you argued that the ministerial exception shouldn't apply to teachers at a Catholic school, even if they were teaching religion. And the line that you used in the brief that stuck out to me was, quote, "Teaching religion cannot automatically dictate ministerial status," close quote. So here's what strikes me as interesting here. I mean, for churches that run schools, they're running schools for a reason. They're running religious schools because they want to teach about their religion. So I'm finding it hard to understand why it is that a religion teacher at a religious school wouldn't be subject to the ministerial exemption. So what am I missing here?
Well, thank you, Senator. Certainly the Supreme Court held that those teachers were subject to the ministerial exception. And just the specific point that you referenced, I believe the point that the brief was making, and again, all of this was in the capacity of an advocate for our clients, but the point the brief was making was that teaching religion alone should not be dispositive because, for example, at a secular school, you might teach religion. Of course, the considerations that you referenced were key ingredients to the Supreme Court's holding.
Right, and teaching religion at a secular school, at a public school, has a different impact, does it not, than at a religious school?
Certainly, Senator, and I think, again, in the capacity of an advocate, the other thing that brief emphasized was this: those teachers taught a range of subjects. But again, I want to be clear, that was, as you know, just the second case on the scope of the ministerial exception. I believe we discharged our duties to our clients in that case. And as a judge, I would take an oath to fairly and impartially apply the law. Okay. And I would do that.
Right, that's helpful. Yeah, the court did rule 7-2 in that case, including with the vote of your former boss, Justice Kagan. I thought the court's reasoning was good. The court concluded, quote, "Religious education and formation of students is the very reason for the existence of most private religious schools, and therefore the selection and supervision of the teachers upon whom the schools rely to do this work lie at the core of their mission," close quote. Okay, so you're telling me you would have no problem, no hesitation in applying the ministerial exception consistent with the majority's ruling in Morrissey?
Not at all, Senator, and I would just say, as I've mentioned a couple times already, that I have great respect for the First Amendment values at issue there and have in fact represented plaintiffs in religious exercise cases as well.
Okay. In another brief that you authored and that you submitted to the Supreme Court of the United States in the June Medical case, June Medical versus Russo, you argued that, quote, "The 14th Amendment protects the right of a woman to obtain an abortion," close quote. The Supreme Court has more recently, in the Dobbs opinion, held that, quote, "The Constitution does not confer a right to abortion." So will you follow that precedent, and do you regard that precedent as binding on you as a judge, and do you support that precedent?
Senator, absolutely. I would apply that without reservation, and it really harkens back to my experience with Judge Griffith. I'll always remember the first day we were all together in his chambers, he sat us down around his table and told us that regardless of any differing personal or political beliefs about how a case should come out, our job that year would be to apply the law and only the law. And we did our best to live up to that. I will do the same if I'm fortunate enough to be confirmed.
Was the Supreme Court right in Dobbs?
Senator, as with any decision of the Supreme Court, I would follow it fully and faithfully. And both the specific holding and the methodology applying Glucksberg's test for unenumerated rights.
Do you agree with the reasoning?
Senator, as a judicial nominee, and again, going back to my experience with Judge Griffith and Justice Kagan, what I can commit to you is my beliefs about the correctness or not of binding precedent would simply play no role in my job as a judge. I take very seriously the Constitution's role calling for independent and impartial judges. Another thing Judge Griffith emphasized was his oath. You take an oath to fairly and impartially apply the law, and I would do that.
Right. Thank you. I appreciate that. Thank you, Mr. Chairman.
Senator